Hey guys, welcome back to another new videos and LawGuru welcomes you. So today in this video we will be discussing the topic criminal misappropriation of property. In the previous video we have discussed cheating in IPC. If you have not watched that video, please go watch that video. I will give the link of that video in the I button. And also, if you have not subscribed my channel, please go subscribe so that you all get IPC related videos regularly. So let's start this video. First of all, we will come to the definition part of criminal misappropriation of property or dishonest misappropriation of property. This offense, that is criminal misappropriation of property, is defined in section 403 of the Indian Penal Code 1860. It says, whoever dishonestly misappropriates or converts to his own use any movable property shall be punished with imprisonment of either description for a term which may extend to 2 years or with fine or with both. What it says that whoever, any person, dishonest intention appropriates or converts any movable property for his own use, that is called criminal misappropriation of property or dishonest misappropriation of property. Those persons who commit that offense shall be punished with imprisonment, that is, he or she shall be put in jail for a term which may extend to 2 years or that the person has to give certain amount of fine or with both. Now we will come to some illustrations. First illustration: A takes property belonging to Z out of Z's possession. There is a property like, for example, Z has a mobile phone. A takes that out of Z's possession in good faith, believing that at the time of taking that mobile phone, he believes that that particular mobile phone is his mobile phone. Here, A is not guilty of the offense of theft, but after he discovers or after he realizes that he has mistakenly picked up the mobile phone of Z, after he discovers his mistake, A with dishonest intention appropriates that mobile phone to his own use. He sells that mobile phone or uses that mobile phone for himself. Then he is guilty of an offense under this section. Second example: A and B being joint owners of a horse. There is a horse and the owners, A and B are the joint owners of that horse. A takes the horse out of B's possession for the intention to ride it. Here, A has the right to use that horse. He does not dishonestly misappropriated it. But in case if A sells that horse and appropriates all the money he gets from selling that horse to his own use, then he is guilty of the offense under this section. Then there are two explanations. First explanation: a dishonest misappropriation for a time only is a misappropriation with the meaning of this section. For example, A finds a government promissory note belonging to Z bearing a blank endorsement. A finds a government promissory note that belongs to Z on a road. A knows that that particular promissory note belongs to Z. Then what A does, A pledges that particular promissory note with a banker as a security or a loan, intending that at a future time he will restore it to Z or give it back to Z. Here in this case, A has committed an offense under this section. Now we will come to the explanation number 2. It says, it has two parts. First part says a person who finds property not in the possession of any other person and takes such property for the purpose of protecting it or for restoring it to the owner does not take or misappropriate it dishonestly and is not guilty of an offense. This is the first part. It says A person, supposedly A, finds a ring lying on the high road. The ring belongs to B. What A does, A picks that ring and go to police station and says that I found a ring lying on the road. Or he tries to find the owner, that is B. Then he is not guilty of that offense, as he is not misappropriating it. But he is guilty of the offense above defined if he appropriates that particular ring. In case of the example of ring that I gave, he is guilty if he appropriates that particular ring to his own use when he knows or has the means of discovering the owner, when he knows that it belongs to B, or he has the way to discover that, or he has the means how to discover the owner of that particular ring. Then he has committed the offense of criminal misappropriation of property. Now, what is a reasonable time? It is not necessary that the finder should know who is the owner of the property or that any particular person is the owner of it. It is only sufficient if at the time of appropriating, at the time when the person is appropriating that particular ring for his own use, if he does not believe it to be his own property or in good faith believe that the real owner cannot be found. Now we'll come to some illustration. By reading some illustration or understanding some illustration, you will get to understand this concept better. First example, A finds a rupee on the high road, not knowing to whom the rupee belongs. A picks up the rupee. Here A has not committed the offense defined in this section. Why? Because he has only picked up that rupee. He has not appropriated that rupee for his own use. If he appropriate that particular rupee, then A has committed that offense under this section. Second example, A finds a letter on the road containing a bank note. From the direction and contents of the letter, he learns to whom the note belongs. Now in this case, A knows to whom the bank note belongs. Then also he does not give that bank note to the person it belongs. He appropriates that note for his own use. So in this case, he is or A is guilty of that offense under this section. Now last example, A sees Z drop his purse with money in it. A sees that Z is passing by and he has dropped his purse, and in that purse A sees a lot of money. Then A picks that purse with lot of money with the intention to restoring it to Z. First he thinks that I will restore that purse to Z. But afterwards, after seeing that lot of money, he appropriates to his own use. He changes his mind. In that case, A has committed an offense under this section. Second section, that is related to dishonest misappropriation of property possessed by deceased person at the time of his death. This particular misappropriation of property is defined in section 404 of the Indian Penal Code. It says, whoever dishonestly misappropriates or converts to his own use property, knowing that such property was in the possession of a deceased person at the time of that person's decease and has not since been in the possession of any person legally entitled to such possession, shall be punished with the imprisonment of either description for a term which may extend to 3 years, and shall also be liable to fine. And if the offender at the time of such person's decease was employed by him as clerk or servant, the imprisonment may extend to 7 years. Now what this section says? The section says, whoever, any person who dishonestly misappropriates, who with dishonest intention misappropriates or converts to his own use any property belonging to a deceased person at the time of his death, then that is called dishonest misappropriation of property possessed by deceased person at the time of his death. If any person commits that offense, he will be put in jail for a term which may extend to 3 years, or he or she has to give certain amount of fine, or both. And if the offender who is committing this offense at the time of such person's decease was employed, if the deceased person has employed that offender, supposedly a maid servant, A has employed a maid servant Z, and A's legal heir is B. So in this case, at the time of A's death, before B gets all the property, all the money of A, if Z gets that property or money and misappropriates to his own use or converts to his own use, then that is called dishonest misappropriation of property possessed by deceased person at the time of his death. And if the deceased person has employed that clerk or servant, then that offender will be put in jail for a term that the period may extend for 7 years. Illustration: Z dies in possession of furniture and money. His servant A, before the money comes into the possession of any person entitled to such possession, before the money or the furniture comes into the possession of any legal heir of Z or any person who is entitled to get such possession, A gets all that money and furniture with dishonest intention and misappropriates it or appropriates it and converts it to his own use. Then in that case, A has committed this offense, that is the criminal misappropriation of property, that is section 404 defined in this section. If you like this video, press the like button, share it, subscribe for more such videos. If you have any doubt in this video, please do comment. For then, stay safe. Thank you.